Chapter 7 is titled Strict Liability and Product Liability. For starters, strict liability is basically liability without fault. It, by definition, is basically a company can be held responsible for their responsibilities and any harm that they caused, despite if it was on purpose, even if they used the utmost care, I think the book says. So, and this liability is usually applied to situations where extreme risk is present. So maybe, like, for example, products or services to children or the elderly, or where extreme risk could occur. And with that comes product liability, which is just like a more specified version. So this is just the liability of manufacturers and sellers for harmful and defective products. And so this liability, these can be based off of negligence, misrepresentation, strict liabilities, or maybe a mistake with a warranty. The negligence includes failure to exercise the degree of care that maybe is reasonable. Or a lot of this happens is if they're trying to cut costs or cut corners, make things easier, and then it turns out to be bad. It can also include, like I said, misrepresentation, which can be fraud. That happens a lot, where they say maybe there's false advertising on it, there's false marketing that tells the consumer something untrue. So here are some assumptions that product liability is implied through public policy. So it's actually like all companies have to go through this, and it applies to everyone. So the assumption is that consumers should be protected against unsafe products, but really they kind of put public policy puts it on the manufacturer distributor. They cannot escape, manufacturers and distributors cannot escape the liability simply because they are not in privity of contract with the user, which privity of contract means it's the relationship between the parties of a contract. So even though they're not in contract with the consumer, they still are responsible. And also, they are deemed liable because they ultimately can bear the costs associated. Like, say they get sued for something, they can bear the cost because then they can just put it on their product and up the price, and that's what usually happens. So they always get the money back. So really, they're liable, but they always find a way to bring that money back. Here are some requirements in order to apply by the rules. Product must be in defective condition when sold. So it must be okay. The defendant must be selling or distributing the product. So these are all requirements in order to be a court case and deem the distributor liable. The product also must be unreasonably dangerous, and that's actually a rule in most states. It's not like that in everything or in everywhere. The plaintiff must incur physical harm to self or property by the use of the product from the distributor. So there must be like physical damage somewhere. The defective condition must be the immediate cause of the injury or damage. It can't be like a third party, like, oh, this caused that to hurt me. No, it needs to be direct. And then lastly, the product must not be changed from the time it was sold to the time of injuries. So, it can't be like changed in any way that would cause harm. It has to be directly from the package, directly from the box, or whatever it may be. All right, and then all of these can be the defects, like it can be in maybe manufacturing, design, and it could even be in the inadequate instructions or warnings on the product or service. So yeah, that's it for Chapter 7. And then Chapter 8 is intellectual property rights. So this was all about trademarks, trade names, copyrights. First of all, trademarks are the marks or mottos or devices that implement a manufacturer's stamps. It's printed to the goods it produces so that they can identify the market that it is from. And you can register these trademarks with the state or federal government, and they must be distinctive to identify that manufacturer. So, for example, Coca-Cola. I think that was used in the book a lot. It can have service marks too to distinguish the services, maybe if they don't have like an actual product that they're selling. They also use a certification mark to show the region, materials, manufacturer, and other characteristics of the service, just because since it is a service, it's not like an actual object, so then you're supposed to show the other information where the service comes from. Example of this was Unity Point Health, which I thought, I'm from Sioux City, so there's a St. Luke's Unity Point Health hospital here, and they were expanding into Wisconsin, where Unity Health, just a company called, or a hospital called Unity Health, already existed. So Unity Health was protected since it would create confusion for customers. So Unity Point Health was forced to change their name and couldn't copy, even though they were basically they had a trademark, but they couldn't use it because it would confuse consumers. A rule against this is generic terms such as bicycle or computer are not protected, even if they have secondary meanings, just because they're very generic and it's hard to distinguish. Like, you can't choose that name just for you when it's like used in so many different ways. The trade name can indicate a part or all of the business's name. So this is kind of inside a trademark. It can be, a trademark can protect the trade name that's underneath it for a company. To license this, you need to find an agreement or contract permitting the use of a trademark, copyright, or patent. Like I said before, you have to get this with your state or government. A patent would allow, if something is new or you discover something, a patent allows protection against that and gives you the rights to anything. And it can also be improvements or anything. If there is infringement on this, these patent if you have a patent, it allows you can get a lot of money if someone copies you in any way. With that, copyright is the last thing it talked about, and these are intangible property rights granted from the federal government to literary or artistic production. So I think about this in books. This is a lot of the time. They copyright these, and there's some specific rules that you have to follow. It protects the life of the author plus 70 more years, and after that, the rights go to the people, so it's not owned. And they originally, they used the example of Sherlock Holmes every time it was being used until 2013, I think it said. People were paying for it, and then it finally changed where it became the right of the people and owned by the people. That's it.